listening to Driving Law, a podcast by Kyla Lee about all things related to the rules of the road.
Hello, and welcome to another episode of Driving Law. I'm Kyla Lee at Acumen Law, and with me, my co-host, Paul Doroshenko.
Well, of Acumen Law, but today we're in your tiki basement. And Kyla's tiki basement is something to see because it goes way back. It's long and expansive, and the entire basement is tiki.
Tiki
I suppose
room.
we can cover other spaces down here and other times we do the podcast.
No. You mean, I thought you meant cover other spaces. It's not done yet. There's still more to do.
I know, but it goes a long way. There's a lot of tiki here.
Yeah.
If you don't live in Vancouver, you may not know that everybody in Vancouver has their basement fully converted to living space because it's so damn expensive here that every square inch is used. And Kyla's entire basement is tiki except the laundry room. So here we are. And, well, the bathroom's got a little tiki in it.
It's got a touch of tiki.
Yeah.
Okay, anyway, this is not the tiki podcast, although I wish it was. This is the Driving Law podcast. And I wanted to start by talking about a case that came out in Ontario this week about the admissibility of certificate evidence.
You sent it to me.
I sent it to you and you did
And
not
I've
read it.
been so busy.
Yeah.
And if you don't know, if you're outside of BC, we have a provincial government strike that we've talked about. And the provincial government strike has led to us not having any hearings in our office because the adjudicators are also not working. And at the same time, the BC liquor distribution is not distributing. We have a craft distillery that we run, and craft distilleries can sell to restaurants, pubs, and private liquor stores. So I've been working 14-hour days in the distillery.
I've been working too. I spent my vacation weekend delivering in boots and picking up boots.
All I'm saying is that's why I didn't read the case.
Okay. Anyway, it's just thought you were like, it's only me that's working.
No,
I'm still keeping
You've been doing
all sorts
filling
of
in for me.
Okay, so the case is called Klemp, and it is about a man, Mr. Klemp, who gets arrested for impaired driving. He's taken back to the detachment, and after he does the breath samples, the police officer shows him the certificate of qualified technician. This is the document that has the readings for what your blood alcohol level was. It gets introduced in trial. They don't have to call the technician to come and testify. It's like an admissible hearsay shortcut. So they show it to him, and he's like, okay. And then they put him in cells because he's drunk and leave him in cells overnight. And then he's released the next morning. And he argues at trial that the certificate is not admissible because one of the statutory preconditions for admissibility were not met. That condition being that he needed to be given a copy of the certificate.
Oh, so he's only shown it and not given it.
He was only shown it and not given it. And the Crown says, well, showing it is giving it because the whole point is to give them notice that it's going to be put in evidence and what their readings were. If he's shown it, it serves the same purpose. As though a drunk guy, too drunk to care for himself and has to be lodged in cells, can understand the wording on that thing.
There are probably 1,000 questions you could ask at trial with respect to breath testing that the Crown gets to keep defense lawyers from asking by filing a properly served certificate.
Yeah.
It would end up being 3 days more of trial, and I can tell you a lot more people would be acquitted if we could cross-examine on all of those issues. But there's all of these presumptions that are written into the criminal code that I don't agree with, but, that's just because I don't agree with it. The government gets to write the legislation, but that are written into the criminal code, and they get these incredible shortcuts as a result of having this certificate provision. But generally speaking, they got to comply with it.
Yes. And so that's effectively what the court says is, look, you get all these shortcuts. Hearsay evidence is going in. There's no right to cross-examine. You have to make an application and reveal your defense if you want to cross-examine on anything in that certificate. So it's like not just constrained in the sense of a hearsay admissibility exception, but also the ability to challenge the hearsay. So it's significant. and that's why there's a requirement for strict compliance. They also note that the language in the criminal code is that the certificate be given to a person, and given doesn't mean shown. Like, from a basic statutory interpretation standpoint, it can't mean that. So that is also something that they rely on. But
So in the decision.
Yes. But here's the thing I wanted to tell you about it, because I had an interesting thought. So what the court ultimately concludes is that provision of the certificate, giving the certificate to be compliance with the code, means a permanent transfer of the document from the police to the accused. This can occur either to the accused directly or to the accused, counsel through disclosure, if there is some evidence led at trial that it was provided that way. But here's the but. My wheels are turning.
Yeah.
What about Bassey and the implied undertaking on disclosure, where you're given disclosure and the Crown's like, this is the property of the Crown. We're giving it to you temporarily so that you can defend yourself, but it remains our property. It must be returned to us. We're giving you notice of our intention to rely on all of the documents in here for all of the potential purposes they could be relied upon, which is stupid, like as a cover letter. But this is still our material, and you can't use it for any other reason whatsoever. To me,
it's not transferring it as property.
That's not permanent transfer of the document.
No.
Unless they're going to waive the implied undertaking over the disclosure package.
Well, they could waive the implied undertaking on the certificate alone.
Well, I think what we do now in every impaired driving file is we write the Crown and ask, our client has instructed us to seek the Crown's consent to waive the implied undertaking. Do you consent?
And see what they say.
Mm-hmm.
Yeah.
Because I know their policy is they say
the implied undertaking, and this remains the property of the Crown.
Yeah.
Yeah, that's a good way to do it. But, for us in BC, I can tell you it's very rare to see a police officer do something like this. So I don't think we're going to see a case like this. We have certificate issues from time to time. They're usually different certificate issues. I had one case where the handwriting switched from the technician to the main investigating officer for some numbers that were probably missing. So that was, an example of the type of thing we see. But seeing this is pretty unusual one.
Yeah. Most people are just given the certificate and sent home.
But why say that it's becomes the property of it? It's a permanent transfer. I mean, should it just not be notice, but notice that you can carry away and take to your lawyer? Like, shouldn't that just be the issue? It is notice. Property or not, whatever, you don't have to make a decision in it. It's notice, and it's notice that you can then take and give to your counsel to say, look, this is what they gave me. What does this mean?
Think about what a gift is in law. If I give you $100,
yeah,
that becomes yours. You get, the right to the $100 that is defensible against the entire world.
Yes.
So if you're given a certificate, if that's what to give means in law, are we departing from the ordinary definition of give for the purposes of making the Crown's life easier by not having to give a document to the accused or give it to their counsel through a separate process? Or
I'm conflicted, because I'm on your side. Yeah. In the very clear sense that I think the presumptions are ridiculous. And so any way that I can find around those presumptions, I'm going to be looking for.
Oh, for sure. Like, I'm going to make every cheeky argument I possibly can on behalf of my client. And you do. Sometimes judges don't appreciate that, but
they should. There's creativity. They should admire the creativity, A, and they should be looking to hold the government to account, B.
Yeah.
John Collins did a TikTok this week on the falling away of the presumption of innocence, of the sort of sense that people have that he's got jurors, people on TikTok, all of these people who suggest to him in their comments that the presumption of innocence is being degraded. And I would be one of, had I thought that I would ever be a judge, I would be one of those people who would be vigorously defending the presumption of innocence and holding the Crown to account.
That's why neither of us will be a judge.
Exactly.
I'd stay everything.
But I see the presumption of innocence being degraded even at the judicial level. So
I mean,
certainly at the
legislative
at the
level?
legislative level.
Well, that's a great point for us to transition into the big announcement by Mark Carney yesterday, which was that on Monday, his government, not he, I guess it'll be the Minister of Justice, but his government,
He makes the announcement.
yeah, will be tabling legislation that is going to be tough on crime. Gosh, though, never thought a liberal government would utter those words.
No, they do all the time. It's just that, it gets co-opted by the other guys. Everybody's tough on crime. There's tough on crime. We're going to be the ones who are tough on crime.
Yeah. Anyway, the tough on crime approach is going to be creating more reverse-onus situations for bail, which I don't think is going to have any impact on driving law. I can't imagine they're going to make, drunk drivers have to prove why they should be released.
Well, they could, they already have to on repeat.
Yeah.
Although the police generally just release them, because they would likely be released. The issue is that very rarely do you see it where they are repeat during their suspension. So they're suspended. That's the one that argument can often be made. Of the threat to the public.
So the other things that are going to be in this bill are going to be changes to allow consecutive sentences. And you know why I'm making these air quotes?
Because everything's going to be subject to constitutional validity, and many of it won't be constitutionally valid, or because it's really going to just be the same thing.
Yeah, it's going to be the same thing. Consecutive sentences are already allowed. The only time consecutive sentences aren't allowed is consecutive life sentences. But essentially, they're going to want to make changes so that if you get convicted of 3 thefts, instead of doing 90 days on each all at the same time, you'll do 3, 6, 9 months in jail, which makes no sense. I mean, and it's not going to even be mandatory, and judges are not going to do it.
Well, judges will do what they're going to do when it comes to sentencing because they've got broad discretion with sentencing, and the Supreme Court of Canada has said that over and over and over.
And
so
if they weren't imposing consecutive sentences before, they're not going to be imposing now. But where I do think consecutive sentences may become more common is in the driving context.
Yeah, that's exactly what I was thinking. So
if you have a dangerous and an over 80, if you have, there's already a
that already happens to some extent.
Yeah, there's already law that says if there's a hit and run, that sentence should be served consecutively to any other driving offense for obvious reasons, because you want to discourage the public from adding that element.
Well, impeding the ability of the justice system to investigate when you have a duty to stop.
Yep. So we'll see. We'll see what the legislation says about consecutive sentences. I fail to see how it can be written in a way that leaves the discretion with judges, amends the code in any substantive way. But we'll see.
See, for the most part, the law is as, when they talk about toughening the criminal code, they talk about cracking down, getting tough on crime. For the most part, the criminal code is as tough as it can be and constitutionally valid.
Yep.
And that's really the limits to it. And if they don't like the Charter of Rights, they can try and amend the Constitution.
Yeah.
Good luck to
get all the provinces on board with that.
Otherwise,
actually, they could right now on the bail issue, because all the provinces are on board on that.
Well,
not that I should be giving this away.
Well, they still would have to go through it, and they have to get, in some provinces, they have to get the 2/3 majority in order for there to be a constitutional amendment, and there's all it's a non-starter.
No.
But
it would cost too much money.
If the Conservatives were elected, we would just be perpetually in charter litigation, because almost everything that they passed last time with respect to sentencing was found to be unconstitutional.
Which brings me
tough
to
on crime stuff.
Which brings me to the other thing that Carney says is going to be in this bill, which is restoring some of the conservative government's bans on CSOs. So conditional sentences, so house arrest rather than going to actual jail. And that he says he's going to eliminate a lot of the changes that were made under Trudeau to allow CSO for offenses where the previous legislation had not allowed for a CSO, which to me is interesting. Not only because it's like a reverse course on the party's position, new leader, I get it, but also because why are we filling our jails with people we have to pay to keep in jail when we can have them pay to stay at home?
Well, the upsetting thing for me is that back when I used to do a lot of cases where, early in my career, where I was doing cases where people were facing CSOs, particularly for drug offenses and things like that, I almost never had anybody who violated their conditional jail sentence.
Super rare.
It was super rare. And people really got the message, and they knew that they were lucky to have avoided going to real jail. And most of them got productive and actually went to work, did their stuff, contributed back, turned around.
Get a job to get out of the house.
So what's the whole point of a sentencing is rehabilitative.
Yeah.
You can't change the fact that somebody committed the offense. All you can do is try and make it so they don't continue to commit offenses when they're in the public and free to be moving around again. One way or another, they're going to either get out of jail or they're going to end their CSO, which is jail at home. And so, for the rehabilitative aspect, getting rid of CSOs is a huge problem. It's the type of thing that you and I should actually consider presenting to Parliament on.
Well,
but it's a little bit outside of my wheelhouse, and there's probably other lawyers who can explain it better than we can. It's just an issue of whether or not people get out there, and I would encourage people, if you're a lawyer, you can go and present to Parliament. Anybody can present to Parliament or the Senate committees.
You can write a submission. Whether they invite you to speak is another issue. But remember, when those changes came in, a bunch of driving offenses that didn't allow for CSOs, impaired driving causing death, dangerous driving causing death, over 80 in a death, refusal death, bodily harm. CSOs became available then for those offenses where previously they were not.
Well, and I think they would have been struck down, though, those restrictions on it.
Probably.
Because it's just a matter of the right case. The problem is, very rarely do you have the right case. You have some terrible facts. Where a CSO is probably not appropriate, and you're not going to be running in there, or it's marginally appropriate.
I mean, he says the intention is so that people who commit sex crimes aren't out in the public wandering around.
We keep hearing of Randall Hopley, the fellow who was released or was on escape from a halfway house or something, and then he's been released again. We know about it but a little bit more, not because we had any representation with him, but because the police came to our office looking for footage from our cameras on the outside of our building to see whether or not we had captured him on the cameras. And in the end, that was a really no consequence as far as I could tell, because so what if he walked by? They knew he was there. What are they going to see if he changed his appearance or something like that? Anyway,
they're pretty distinctive appearance.
By the time we got around to actually going through our camera system and looking, if he had walked by, you wouldn't have known it.
You know why you know Randall Hopley's name, though? Is because he's the exception and not the rule.
He is the exception and not the rule. Every once in a while, you hear of some horrible crime and you find out it's the same person who did something before, though. And then that leads to the people in society being upset and being worried about not being protected. And, people forget that we have 40 million people, and the vast majority of us go through our lives without being subject to any violent crime. Property crime, though. Oh my gosh. I've been subject to so much property crime. A victim of crime so many times. Theft, multiple times, mostly vandalism.
The tax for living in the city, Paul, is property crime.
Yeah, that's your spin. I'm the tough on crime when it comes to property crime.
My inner socialist coming out. Okay, since I'm being ridiculous.
Yes, you are.
Maybe it's time for
the ridiculous driver of the week.
And I like this one. It's a little bit in time for spooky season, and you told me I wasn't allowed to do any fun Halloween things until after Thanksgiving, but then you went away and I did them anyway.
I saw that.
Yeah.
As
I put up all my Halloween decorations.
Halloween decorations on the other side of the tiki basement and around.
Anyway, this was an Ontario driver, a learner driver, who was found driving recently, pulled over by police because he had a skeleton in the passenger seat.
So driving like a learner, had to have a supervisor?
Yeah, he was a 19-year-old G1 driver, so I guess that's like the equivalent of an N?
N or an L?
An N, I think. No, it's an L. That's an L.
So that's learning to drive must have a supervisor.
Yeah.
And the supervisor was the skeleton.
Yeah, he had the model skeleton in place of the real life passenger. I guess maybe so he didn't get pulled over. Like somebody would see a figure in the seat and assume he had the supervisor.
God, if you had the driver's license, I have my dad's driver's license still. He passed away a few years ago.
I mean, and the requirements in Ontario are that the supervisor only has to have 4 years of driving experience. You'd think if you get to the point that you become a full-on skeleton, you probably had a lot of years of driving experience before that.
I just, it still wouldn't be my dad, I guess. You wouldn't have the skeleton, but
Yeah. Just to be clear, it wasn't a real human skeleton. It was a model skeleton.
Yeah. Anyway, I can see it on Kyla's computer here.
Yeah.
It looks pretty good.
Very
Google it.
Yeah. So that's our in time for Halloween.
Okay, it says right there in the story they must drive with a fully licensed driver with at least 4 years of driving experience. So there you go.
If you're dead and your license hasn't expired yet, your skeleton, I guess, is licensed.
Honestly, A+ for creativity. And there should be nothing more than a warning in this case. That should just be, okay, you got us this time. Don't do it next time. Don't, use a stuffy or something like that. Don't.
Yeah.
Sorry to interrupt the end of the podcast.
Yeah, that's right.
Pretty funny.
Well, that's our podcast. If you have a driving law related issue, you can get in touch with us at 604-685-8889 or find us online at vancouvercriminallaw.com and tune in next week for another exciting episode of Driving Law.